Good afternoon, everyone. This is Christine Zako, Senior Counsel in Husch Blackwell's Higher Education Group. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console are multiple application icons for your use during the program today. I would like to take a minute to highlight a few of the key icons for you. If you have any questions during the webcast, please submit your question via the question box. We will try to answer all questions during the program today, but if a fuller answer is needed or we run out of time, it will be answered later via email. We truly appreciate audience participation and encourage you to submit questions. A PDF of the presentation is available in the resources folder. This program is pending approval for continuing legal education credits. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your business needs. That is all for the housekeeping items, and let's get started with our program. Joining me today is Ellen Armentrout. Ellen's practice consists of working with her clients on compliance issues, including the Clery Act, Title IX, and VAWA. She advises on public records requests and policy development, as well as all types of governance documents. In addition, Ellen helps clients ensure that institutional policies and practices comply with the relevant accreditation standards. So today we are going to go over the legal requirements related to pregnancy discrimination, some case laws, some hypothetical scenarios, and some practice pointers for you. As we start with the legal requirements, much of our session today is going to be focused on Title IX, but we did want to go over some of the other laws that may also apply. So we're going to discuss those briefly at the beginning of the program. The first we're going to talk about is the Pregnancy Discrimination Act. Title VII, as amended by the Pregnancy Discrimination Act, prohibits employment discrimination based on current pregnancy, past pregnancy, potential or intended pregnancy, and medical conditions related to pregnancy or childbirth. And when we get to the case portion of our presentation, a couple of those are going to relate to the employment context in Title VII. ADA Section and Section 504 are two federal laws that prohibit disability discrimination and require institutions to make reasonable accommodations to qualified individuals with a disability. As you see here, those laws define disability to be a physical or mental impairment that substantially limits one or more major life activities, a person who has a history or record of such an impairment, or a person who is perceived by others as having such an impairment. So pregnancy itself is not defined as a disability, but complications that might arise during a pregnancy or in childbirth or following childbirth may qualify, depending on the nature of the limitation. Title IX, which we are going to spend the bulk of our presentation discussing today, says that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So Title IX's regulations give us some additional detail regarding the scope of the protections under Title IX. One of those is that there must be gender-neutral rules. So a recipient shall not apply any rule concerning a student's actual or potential parental, family, or marital status, which treats students differently based on sex. Another portion of the regulations deals with equal participation. A participant cannot discriminate against any student or exclude any student from its education programs or activities, including classes, extracurricular activities, athletics, etc., on the basis of pregnancy, childbirth, false pregnancy, termination of pregnancy, or recovery therefrom, unless the student requests voluntarily to participate in a separate portion of the program or activity. This is probably more common in the K through 12 context than what we see in higher ed, and really not one of the questions that we typically get asked, but it is an important thing to be aware of. Something which is more common is medical certification. And the regulations say that a recipient may require such a student, a pregnant student, to obtain the certification of a physician that the student is physically and emotionally able to continue participation so long as such a certification is required of all students for other physical or emotional conditions requiring the attention of a physician. We're going to dig in this to a little deeper as we get into the hypotheticals. Related to the separate programs, the regulations say that when a recipient does operate a portion of its programs or activities separately for pregnant students, of course, the admittance to which has to be completely voluntary, it shall ensure that the separate portion is comparable to that offered to non-pregnant students. Again, something that we see more often in the K through 12 context, but something to be aware of if these separate programs are being offered at your institution. Another key part of the regulations addresses temporary disability policies. And the regulation says that the recipient shall treat pregnancy, childbirth, false pregnancy, termination of pregnancy, and recovery therefrom in the same manner and under the same policies as any other temporary disability with respect to any medical or hospital benefits, service, plan, or policy which the recipient offers as part of its education programs or activities. And finally, and perhaps the most challenging of the regulations, deals with leaves of absence. And the regulations require that whether it's for pregnancy, childbirth, false pregnancy, etc., that the student be allowed to take a leave of absence for whatever period of time is deemed medically necessary by the student's physician. And at the conclusion of that period, the student shall be reinstated to the status which she held when the leave began. And this, as I said, is perhaps one of the most challenging portions of the regulations and something that we're going to spend a great deal of today's session talking about. So in addition to the Title IX regulations, OCR has issued some guidance around pregnant and parenting students. And this guidance is from June 2013. It is available on OCR's website, and it is called Supporting the Academic Success of Pregnant and Parenting Students. And if you pull up this guidance, one of the first things that you will notice is that the focus is very much in the K through 12 context. But the document itself does state that the legal principles involved apply equally to higher ed institutions. And certainly this is guidance which OCR has used as a basis for many of the resolution agreements that we see also promulgated on their website. So in that guidance, OCR says that schools must protect students from harassment based on pregnancy or related conditions, and must possess and distribute a policy against sex discrimination. OCR recommends that this policy make clear that sex discrimination covers discrimination against pregnant and parenting students. Another thing that OCR's guidance says is that schools must adopt and publish grievance procedures for students to file complaints of sex discrimination, including discrimination related to pregnancy or parenting. So we're all very familiar with the regulatory requirements to have Title IX grievance procedures that address sexual harassment, as those have been defined by the new regulations. Just don't forget that those grievance procedures, it can use a different process, but they need to encompass sex discrimination complaints as well, which include pregnancy discrimination. And of course, as you all should know, you need to have at least one employee designated to carry out Title IX responsibilities. In terms of OCR's guidance on a day-to-day basis in dealing with these situations, They say that schools must allow pregnant students to continue participating in classes and extracurricular activities. So for example, if a student is involved in athletics, we need to allow them to continue to be participating in that. We have to allow pregnant students to choose if they want to participate in special programs or classes for pregnant students, and we can't pressure them to participate in any separate programs. And where necessary, we may need to provide reasonable adjustments, such as a larger desk, or if there's an elevator that students would normally not have access to, that may be something that they need access to during the period that is necessary because of their pregnancy. OCR's guidance also states that we must allow pregnant students to return to the same academic and extracurricular status as before their medical leave, including the opportunity to make up missed work. This can take a variety of forms in terms of what that opportunity to make up missed work might entail. OCR gives examples of allowing a student to retake a semester, for example, or to allow additional time in a program to finish at a later date. OCR also says that we must ensure that teachers understand the Title IX requirements. They cannot have their own policies about class attendance, for example, or making up work that conflict with the school's Title IX obligations. So, for example, an instructor cannot prohibit students from submitting work after a deadline missed due to pregnancy or childbirth, and they must allow students to make up missed participation and attendance credit. And finally, OCR says that schools must excuse absences due to pregnancy or childbirth for as long as medically necessary, and they must provide pregnant students with the same special services that they provide to individuals with temporary medical conditions, whether that might be the ability to have remote instruction, tutoring, or an independent study. And going back to medical documentation, OCR says that schools may only require pregnant students to submit a doctor's note if the school also requires a doctor's note from all students who have a physical or emotional condition requiring treatment from a doctor. So, for example, a student who has been hospitalized for childbirth must not be required to submit a medical certificate to return to school if a certificate is not required of a student who's been hospitalized for another condition. So I'm going to turn it over now to Ellen, who's going to talk about some recent cases in this area.
Good afternoon, everybody. Thank you, Christine. Thank you all for coming. Like Christine said, I'm going to talk a little bit about some recent cases. Some of them are not so recent, but they stand out, and so I will make note of those when we get to them. These cases generally are going to be providing recent examples of pregnancy discrimination decisions involving higher ed. We've tried to pull a representative sampling of cases from a variety of different jurisdictions, and the cases cover a range of factual scenarios and involve both students and employees, including faculty. As Christine mentioned, our focus today is Title IX, but some of these implicate other statutes like Title VII and even the ADA, as well as certain state laws. Part of the reason that we have pulled these cases is that oftentimes the allegations overlap, particularly in the Title IX and Title VII context, and there is an overlapping analytical framework as well. So you'll see a lot of similarities in the cases, even when they've perhaps been filed under different statutory schemes. So the first case I want to talk about is quite recent. The case involving a student, Stanford versus Fox College from 2020. So this was a physical therapy student who alleged that her college discriminated against her because of her pregnancy, by assigning her to a clinical location she found unacceptable and not allowing her to find her own clinical placement. She brought a claim under Title IX as well as under the ADA and Section 504, as well as a claim for intentional infliction of emotional distress. So her first clinical assignment was to a nearby facility, but the facility canceled the clinical assignment for reasons we don't know. The school then assigned the student to an outpatient clinic in Gary, Indiana, and the student felt that the assignment was too far away. It was a 40-minute drive, and it was in winter, and she felt that the environment was not safe. So she asked if she could find her own placement. The school had allowed a student to find his own placement in a previous instance where the student had had a criminal background and so needed to find a place that would allow someone who had a criminal background to participate in the clinical there. Our student, Sanford, in our case, she withdrew temporarily from the program but was allowed to return without going through the admission process because of her extenuating circumstance, which was pregnancy. After she had her baby, she returned, completed the program, and got a job. But she felt that the job she got was lower paying because she had not had an outpatient clinical experience. The court used the burden shifting analysis set forth in McDonnell Douglas to make a determination of whether or not she had experienced discrimination. That analysis, as I'm sure many of you are aware, requires the plaintiff to show that she is pregnant and subject to adverse action, that there's a causal connection between the pregnancy and the adverse action, and then assuming the plaintiff makes that showing, the defendant is given the opportunity to offer a non-discriminatory explanation for the adverse action, and then the plaintiff can show that the defendant's offered reasons are in fact pretextual. In this case, the court found there was no adverse action, in part because the college did not cancel the initial placement. The clinical site had, because the college had placed many students at the Gary facility over the years with no complaints of safety issues, and the Gary clinic was willing to extend the plaintiff's term to accommodate time off for childbirth and recovery. In addition, the court found that the student did not show a genuine dispute regarding whether the college's explanations were pretextual. The school had said there were no other placements available other than the Gary placement at the time the student was placed, and the only student who had been allowed to find his own placement in the past was the one I had mentioned who had the criminal background. So there was nothing to suggest that the school, quote, accommodated a large percentage of non-pregnant students while failing to accommodate a large percentage of pregnant students. So the key takeaways are there was no adverse action and there was no genuine dispute regarding whether the college's explanations were pretextual. So the judgment was for Fox College. This next case, Varlisi versus Wayne State from 2016, also involves a student. The student was enrolled at Wayne State's social work program, and that required her to complete coursework and work placements both. The student volunteered at the Salvation Army. She became pregnant while working at the Salvation Army. And as a side, I will say that the student was unmarried. Her supervisor commented about her lack of a wedding ring, told her to stop wearing fitted clothing, told the students that individuals receiving treatment at the Salvation Army would be sexually attracted to her pregnancy, told her that even though she had, quote, had relations with someone, the men at the rehab facility, quote, can look but they cannot touch. She was told repeatedly to stop rubbing her belly and was told, like I said, that men would be turned on by her pregnancy. This was a student who, up to that point in the program, had had excellent grades, and excellent reviews at her prior work placements. She ended up getting failing marks, which then the department chair relied on to fail the student for the clinical portion of her degree. In her review from the Salvation Army, it was the worst review that the school had ever seen for a student. The student had complained to the university about the treatment that she was receiving at the Salvation Army, but those, according to the court, her complaints had fallen on deaf ears. She had filed a discrimination charge with the school that was never investigated. Her grade appeal was denied, as was her request for readmission. The court found that the decision to dismiss the Salvation Army from the claim was correct because the Salvation Army was not an academic placement under Title IX, and therefore Title IX didn't apply. We're going to see a little bit different outcome later with a different case in a different kind of facility. Ms. Varlese got almost $850,000 reward, and that was upheld because the evidence showed that she was failed because of her pregnancy. So I find this an interesting case because the Salvation Army provided feedback on her work that the university relied on. And while the Salvation Army wasn't subject to Title IX, because the university was, they were found in violation for relying on these failing marks, but also, I suspect, for not following up on the complaints that the student made during her time at the Salvation Army that she had made to the university. Our next case, Cubic versus Central Michigan, is a faculty case under Title VII. I bring this case up, though, because the analysis is very similar to that used in Title IX, and you'll see a lot in these cases as you're looking at them that the court will say, we use the same analysis under Title IX that we use under Title VII, or we use the analysis under Title VII as a guide for our analysis under Title IX. So that's why we've got both kinds of cases here. We've also got both kinds of cases here because both of them show up when you're looking at pregnancy discrimination. It can come under both regulatory and statutory frameworks. So this was a case involving an assistant professor who was told even before her pregnancy and having her baby that her scholarly output was lacking, and she'd been told that on multiple occasions. She was promoted in 2012, but told to increase her scholarly output. She told the school that she was pregnant in January 2013. That spring, she requested an extension of her tenure clock. She gave birth in April. The day after she gave birth, she got an email from her supervisor asking her about grading, saying the students were concerned that another teacher was going to be doing the grading. When would she be able to do the grading? Then in May, so 1 month after she had her baby, her tenure extension request was denied. The following week, she was given teaching choices for the fall. She could choose 5 days a week at 8 a.m. or 3 days a week at 8 a.m. and 2 days a week at 5 p.m. September 2013, which was the same month that she filed a claim against the school for denying her tenure extension request, her tenure committee voted against reappointment, citing limited service and scholarship. In October, she refiled her complaint against the school alleging discrimination and hostile work environment. In November, the provost departed from the committee's recommendation and decided to reappoint, telling her again to improve her scholarship. In April 2014, so a year after she had her baby, an internal investigation at the university found a hostile environment, but no impermissible effect on the reappointment process. In May of 2014, the university granted her tenure extension request. So you can see that there is a lot going on here. There are lots of internal grievances being addressed, and time is marching on, and the university is making decisions about her promotion and her output. In September of 2014, the committee again recommended against reappointment, citing a lack of scholarly output and university service. She filed another complaint, and in January of 2015, she was denied reappointment, and that's when she filed suit. And she filed suit for pregnancy discrimination, hostile work environment, and retaliation under Title VII and the state statute. The court found that the plaintiff did not, and using this same McDonnell-Douglas analysis that we've talked about before, where she was pregnant, suffered an adverse action, and had to show she was qualified for the position, and there was a nexus between her pregnancy and the adverse employment action. The court found that the nexus between the pregnancy and the employment action was not there. The school had argued there was no nexus because it was 5 months between the end of her pregnancy and the vote against her reappointment. The court said that is not too long to say that pregnancy was not the basis, but the court said there was no evidence of a connection between her pregnancy and the adverse action because her pregnancy was not discussed in the decision-making process, and there were numerous concerns about her output similar to those raised before her pregnancy. So, in addition, her allegation that the course assignment she had, the 8 a.m. 5 days a week or 8 a.m. 3 days a week and 5 p.m. 2 days a week, the court found that was not materially adverse. So it was not an adverse action against her taken by the school, and it must be more, an adverse action has to be more than merely inconvenient. There must be a showing of special harm. With regard to her denial of her tenure extension, the court said because the denial was overturned and she was ultimately granted an extension for her tenure decision, it was not adverse to her. So in this situation, she had not shown the nexus between the pregnancy and the adverse employment action, which was her termination. And then the adverse action has to be material, not just inconvenient. So her course assignments were not materially adverse, and the denial of this extension, because it was overturned, was also not an adverse action. Burnett versus University of Tennessee from 2010. This is a little bit longer ago, but I thought it was interesting. This was another Title IX case. This was a situation where a veterinary assistant was working in the large animal clinic, and she had to clean the stalls of diseased animals. Her doctor instructed her to have no contact with animals placed in isolation. The school tried to find other jobs for her and was unable to do so. They reached out to her doctor many times. It was very interesting, seeking clarification regarding her limitations. And the doctor was adamant that she wasn't supposed to be dealing with sick animals because of the risk to her fetus. She was given the option to take a leave, to resign, to be terminated, or have the doctor reevaluate her restrictions. She did not do anything else, and so she was terminated. And the court quoted another case saying, in deciding whether an employer reasonably relied on the particularized facts then before it, we do not require that the decisional process used by the employer be optimal or that it leave no stone unturned. Rather, The key inquiry is whether the employer made a reasonably informed and considered decision before taking an adverse employment action. Here, the university had 4 written communications with and 1 phone call with the physician and determined that the plaintiff could not work safely as a veterinary assistant. So the key takeaway here is that the plaintiff has to show that defendant's action was not reasonably informed. And in this case, the court found that the school's efforts to obtain information and the information they obtained made it so that her termination was reasonable because she simply could not do the job in a way that was safe according to her own medical doctor. So this is a case that turns out a little bit differently from the Salvation Army case that we talked about earlier. It's very recent, as you can see, from 2021. So many female residents at a university hospital brought claims against the university, the hospital, and the residency supervisor, including pregnancy discrimination claims under Title IX. In this situation, the residency supervisor was physical, touching the students, making comments about their bodies, including their pregnant bodies. The university hospital in this situation tried to make the argument that Title IX did not apply because it was a hospital, not an educational institution. So in determining whether Title IX applied to the hospital, the court looks at a series of factors, including the structure of the program, including the involvement of instructors and inclusion of examinations or formal evaluations, whether tuition is required, benefits conferred through the program, such as degrees, diplomas, or other certifications, the primary purpose of the program, and whether regulators accrediting the institution hold it out as educational in nature. In this situation, the university and the hospital had a contract where they formally integrated the hospital with the university, and we see that a lot. The hospital held itself out as a teaching hospital. In fact, the primary teaching hospital of the university's medical school, thereby affiliating itself with the university and holding itself out as an educational institution. In addition, the hospital was receiving federal funds. Therefore, the hospital was subject to Title IX in this case. So I think that that's really interesting. So the Salvation Army wasn't, and the hospital was. You can see why. There are obviously big differences. But I think that that's something that might get overlooked. So those of you involved with hospitals and medical centers should be thinking about that for Title IX, not just the school itself, but also the hospital. So this is an old case. Unfortunately, no one can say that 1997 is recent. The student case, but it's interesting, and the reason I've included it, so this was a nursing student who had a lot of illnesses as a result of her pregnancy. The university offered her accommodations for her clinical class, and the student found them unacceptable, and the student left the program, and she sued the university for disability discrimination under Title IX. The court in this case found that pregnancy can result in disability, and that was unusual at the time. That was before the government expanded its definition of disability to include pregnancy-related conditions in 2008, and that's why I thought this was interesting. The court did grant summary judgment to the university because while pregnancy can lead to disability and students can file cases under both discrimination statutes and Title IX, the accommodations are reasonable if they don't impose undue financial hardship or administrative burdens or a fundamental alteration, but a student not meeting the academic requirements of the program does not have a legitimate claim under Title IX. So the student was not successful in this case, but the court acknowledged that pregnancy some of the side effects of pregnancy and childbirth can be like a disability. Like I said, we now have a statutory, or we have a framework now that accepts that that is the case. That is no longer just a product of case law. This is an interesting case involving a dental student, Murrow versus LSU, 2019, so pretty recent, and this goes back particularly to one of the slides that Christine was talking about earlier with regard to what happens if you don't have a maternity leave policy. So, and again, this court used the McDonnell-Douglas framework, member of protected class, adverse action, motivated by discrimination. So in the fall of 2017, Murrow became pregnant. In late January, early February 2018, she reached out to the school to ask about maternity leave. She was told there was no maternity leave policy. In June of 2018, she was told to register for classes beginning in mid-August and that she should keep up remotely in the meantime. She gave birth in the summer of 2018. On August 16th of 2018, the director of the program emailed Murrow and stated, quote, extenuating medical circumstances aside, our agreement in June was that you would return as a full-time student for one half of the summer semester while completing didactic assignments at home. Advised she was to return as a full-time student on August 27th, or she was told she would have the option of withdrawal or dismissal. She returned to school while suffering from postpartum depression. She was referred to the campus assistance program in October and received a fitness for duty evaluation and was cleared to return on October 29th. 6 months later, she was terminated from the program. She sued for violation of Title IX, failure to provide medically necessary maternity leave, and termination. So the court stated that they were going to analyze the sex discrimination claim under Title IX by looking at the traditional Title VII analysis. And they determined that, like I said here, courts will analyze Title VII and Title IX cases in the same way, and that if a school doesn't have a leave policy, it needs to treat pregnancy and recovery as a justification for a leave of absence for so long a period of time as is deemed medically necessary. And then the student shall be reinstated to the status which the student held when the leave began. So LSU knew of her medical condition and did not provide the leave. That was a violation. However, because she was terminated 6 months after she was cleared for duty, her claim of discrimination regarding her termination was not shown. So I believe the final case that we're going to talk about today is this Kahn versus Midwestern University. I'm going to keep this very brief because this was not a Title IX claim. This was a student who was struggling academically. She was given a chance to complete the program after not meeting the program's requirements at the discretion of the university. She continued to struggle and was dismissed. And after being expelled, she sued the university for failing to accommodate her pregnancy-related disabilities. So I think schools see this a lot, that they will sort of get these overlapping claims. And so the court said the student was not otherwise qualified to meet all the program's requirements in spite of her pregnancy-related disabilities. And again, this was not a sex discrimination claim. It was a disability discrimination claim under Section 504. So I hope that this overview has been helpful. We're going to switch gears a little bit, and I hope these cases have helped us prepare for these. We're going to talk a little bit about some hypotheticals. I'm going to cover the first one. This is Inez's story. So Inez was enrolled in an 8-week certificate course through Blackwell University Nursing. At the end of the 8 weeks, students take a state examination to become a basic nursing assistant. The program has 2 components, 80 hours of lab, 40 hours in the clinical setting where students perform tasks on residents in a nursing home. The 40-hour clinical program requires extensive physical maneuvering and lifting. Blackwell University Nursing's program handbook required pregnant students to notify their instructors as soon as they became aware of their pregnancies and provide written consent from their medical professional to continue participating in the program. BUN does not require students with other medical conditions to provide written medical consent. During week 3 of the course, Inez learns that she is pregnant. So we have a poll question here. Do Blackwell University Nursing's requirements for pregnant students comply with Title IX? A, yes. They are designed to promote safety of parents and child and therefore legal. B, the requirement to inform the program complies, but the requirement for a medical professional's approval does not. C, the requirement for a medical professional's approval complies, but the requirement that the parent inform the program does not. Or neither of BUN's requirements comply with Title IX. So if you all can pick your answers, I'll give you a few seconds to do that. Looks like we're getting some answers submitted. Keep them coming. Keep them coming. All right, we're going to go to the next slide. So I think that the D's have it in this case. In this situation, this is based on an actual OCR investigation. OCR found that the policy as written violated Title IX because it imposed restrictions on pregnant students that are not similarly imposed on other students, including students with physical or emotional conditions. OCR determined that the policy requires pregnant students to notify the program of pregnancy, even if the student is not subject to any medical restrictions, and to provide medical documentation of the student's ability to participate. The policy also requires pregnant students to provide a medical release. The policy states that the clinical placement sites can take measures to avoid potential hazards to mother and/or unborn fetus, even if the pregnant student does not have medical restrictions. All of these provisions were found to be problematic. And now for our next hypothetical, I'm going to turn it over to Christine.
Thanks, Ellen. Let's turn to Amy's story. Amy is enrolled in an accelerated program at Husch College of Nursing. 2 months into the 8-month program, she notifies the nursing director that she is pregnant and is due in February. The nursing director reminds Amy that the college has a zero absence policy, and if she misses more than 2 consecutive days of class or clinicals, she'll be dismissed from the program. When Amy delivers her baby, she misses 2 days of class, including 1 pop quiz and 3 days of clinical. She receives a 0 for the absences in accordance with the college policy, which is applied consistently to all students, regardless of the reason for the absence. Amy files a complaint alleging that she should have been allowed to make up the missed quiz and clinicals. We have another poll here. Please select your choice. A, should Amy be allowed to make up the pop quiz and missed clinicals? A, no, scheduling clinicals is outside of the college's control and there's no way to add extra clinical days. B, no, the attendance policy is applied to everyone equally and allowing Amy to make up the quiz would give her an unfair advantage. C, yes, she should not be penalized for her absences. Or D, both A and B. Give you a couple seconds here to put your votes in. All right, it looks like the vast majority of you are voting C. And that is the correct answer. So remember, the school must allow leave as long as the physician says it's medically necessary, and the student must be reinstated to their status at the start of the leave. This is not necessarily an easy analysis to decide how do you reinstate a student. to the place they were in at the time of their leave. And there are some factors that you can consider when you're conducting that analysis. What is the length of the leave that the student has taken? Obviously, there are some differences if it's 2 days versus 3 weeks. What is the timing of the leave in terms of the content that was missed or the time in the course that was missed? What are the course objectives? Can the material be made up? Depending on, does the course progress from skill to skill? What content was missed and what order was that missed in? And then finally, are there alternate ways for the student to demonstrate competencies and skills in the course? So in this scenario, we see that the student missed 2 days and 3 days of clinical out of an 8-month program. So looking at all of these factors, it is more likely than not that the school can come up with a method to allow the student to make up the limited amount of work that was missed. So I'm going to turn it over to Ellen to do scenario 3, which gives a little different spin on a similar scenario.
Oops. Thanks, Christine. So this is a story about Patricia, and like Christine says, this is a little bit of a spin-off of her hypothetical. So this is a student who's attending university as an undergrad. One of her classes is a year-long class, and the content of the class builds on itself. During the fall semester, Patricia gave birth the Saturday after the first week of classes, missed the following 10 weeks of the 12-week semester, and returned to class a week before finals week. The university told Patricia she would receive an incomplete for the first semester of the course and thus would not be able to proceed to the second semester of the course for this academic year. So, should Patricia be able to proceed to the second semester of the course this academic year, having received an incomplete for the first semester, keeping in mind that this is a year-long course? So, no, she needs to wait until she successfully completes the first semester before she's allowed to proceed to the second. Yes, if she's able to make up the work for the first semester of the course before the second semester of the course begins. C, yes, she should be able to begin the second semester of the course as long as she promises to make up the necessary work from the first semester before the end of the academic year. Or D, every lawyer's favorite answer, it depends. So I'm going to give you all a few seconds to respond. All right, I'm going to go to the next. Interesting. I would say in this case that it depends. And I think it depends on a variety of things, and it's the same thing that Christine mentioned in her reinstatement from leave hypo. The length of the leave, the timing of the leave, the course objectives, the content missed, and the alternate ways to demonstrate competencies and skills. So Patricia was gone most of the first semester, and the second semester builds on the first. The leave was basically most of the first half of the course. So I would say you really need to look at the objectives of the course. Is there material that she had to learn during the first semester in order to understand the second semester? This might be particularly true, say, in a math class. Whereas if it was strictly a lecture class, say in history, she might be able to make up the work she missed the first semester during the course of the second semester. If there were competencies gained during the first semester, or that should have been gained during the first semester that involved, for example, group projects or lab work, she may have missed too much to continue. So I think the key here is to do a specific analysis about the particular leave and the particular student and the particular course, and make a determination about whether she is able to gain the competencies and skills necessary, and if they are absolutely required in order for her to be successful in the second half of the course. Now, Christine's going to talk a little bit about Betty's story.
Thanks, Ellen. So in Betty's story, she's a student at Husch College, and she learned she was pregnant at the beginning of the fall semester. She reached out to Professor Swift to explain her situation and to ask if she could reschedule an in-class presentation that overlapped with the doctor's appointment. The professor told Betty she could submit a written reflection in place of the in-class presentation. However, as the semester went on, Betty missed several more days of class. She did not communicate with Professor Swift to explain the reason for her absences. And at the end of the semester, Professor Swift gave Betty a failing grade because her class participation and attendance was below the requirement. Betty felt she was being punished for missing classes due to her parenting obligations and emailed the Title IX coordinator at the university. The Title IX coordinator did not respond. So quick poll here, did Husch College fail to meet its Title IX obligations? Yes, she should not have given Betty a low participation grade. No, Betty was subject to the same attendance policy as other students. C, yes, the Title IX coordinator should have responded to Betty. And D, I don't know. So we'll just give you a couple seconds to submit your answers. And I think we have everyone pretty much saying, yes, the Title IX coordinator should have responded to Betty. And yes, that is absolutely correct. In this matter that was before OCR, OCR identified the biggest problem with this situation is the Title IX coordinator failing to provide a timely response to the student's complaint. In contrast, OCR found that the school did several things right, and we want to highlight those for you. One, the schools excused the students' absences, which were excused due to pregnancy, childbirth, or recovery, even though the student didn't provide any medical documentation saying that they were medically necessary. So the school really went above and beyond what it was required to do under Title IX. It also offered an academic adjustment to the student to work from home for a period of time during her pregnancy. And it decided that the failing grade was really due to the fact that the student didn't notify the professor of additional absences that were unrelated to pregnancy and childbirth. So there was a mix of absences for different reasons, and where the student, did not get a wholesale excusal for all of her absences, and the school did accommodate her for those related to pregnancy or childbirth. Okay, our last hypothetical involves James. He is enrolled at HB Community College in the fall. In October, his partner gave birth, and James missed a week of classes to support his partner while she gave birth and spent time with his newborn child. When James returned to school, Professor Taylor informed him that his absences would not be excused. Professor Taylor only allows students 2 unexcused absences over the course of the semester, and James had reached 4. Professor Taylor told James he should drop the class or he would receive a failing grade. James then dropped the class. So quick poll, did Professor Taylor violate Title IX when she refused to excuse James's absences? A, yes, his absences should have been excused under Title IX. B, no, Title IX does not allow for accommodations for James because he's not pregnant. C, no, Title IX does not allow for accommodations for James because he is a man. Or D, it depends. Give you just a couple seconds. All right, it looks like answers are fairly split between James's absences should have been excused and it depends. Now, this is a tough one, and I think that this is based on an OCR complaint, which was resolved against the institution, and OCR said that James should have been accommodated. Now, unfortunately, there wasn't enough detail in the letter of resolution for us to really dig into the particular reasons why that was. But there are a couple of key takeaways here. One is that rules or policies that relate to parental, family, or marital status must be applied equally to all genders. So if a school provides leave for childcare, for sick children, for bonding time with new children. That leave must be applied equally to both mothers and to fathers, and it can't be differentiated based on gender. However, the leave rules themselves for pregnancy, childbirth, false pregnancy, and termination of pregnancy or recovery therefrom, those are linked to those leaves being medically necessary. And so we're getting a lot of questions in the chat here about whether fathers have similar leave rights to the mothers related to the childbirth or needing to take care of children following their birth. And under Title IX, there isn't an FMLA type equivalent for students. The leave provisions under Title IX are related to the leaves being medically necessary. Other policies and other rules that relate to more general leave or parental status are what need to be applied equally to both genders. Now, I'm going to turn it over to Ellen so that we can wrap up with some practical guidance.
Thanks, Christine. So I'm going to whip through some helpful information to take moving forward as you're looking at these issues. The first is that we recommend that you use inclusive language in your policies. Much of the language surrounding pregnancy is not gendered, and now we have students of many genders who might be pregnant, and so regardless of a student's gender identity, they are protected through their status as a pregnant person, so keep that in mind. In addition, we recommend faculty and staff training. In an ideal world, you would be able annually to provide a full training to faculty and staff regarding pregnancy discrimination. But if you can't do that, consider, for example, sending an email containing a list of protections or sharing contact information for the school's Title IX coordinator. Faculty ignorance is not an excuse for failing to meet your Title IX obligations. In addition, consider ways to make sure that students know their rights and that they know where to turn if they have any questions. Review your institutional policies. Specifically address pregnancy in them. Clear policies will make all the difference. In addition, collect some data on your pregnancy-related issues, leaves taken, concerns raised, complaints made, coursework issues, issues with clinical sites. Look at all that information and determine if any changes need to be made to your policies. Some problems that we see and that some came up in the hypotheticals is absence attendance policies, targeted medical documentation requirements for people who are pregnant, requirements to restart programs from the beginning rather than status at the time of the leave began, and deference to discriminatory clinical sites or clinical site policies. In addition, don't let your faculty members go rogue and come up with their own policies. That goes back to some of the training. And consider policies and practices that give pregnant and parenting students options. So withdrawal should only be at the initiation of the student, and we should also think about creating individualized plans for students who are pregnant. Review your procedures. Make sure that the Title IX coordinator is responding, that students are receiving timely responses. The best policy in the world doesn't help you if the people who are responsible for implementing it aren't doing a good job. So I have left us a grand total of 1 minute for questions. I'm going to turn it to Christine to see if she has looked through and any that she might be able to answer quickly.
Yes, thank you, Ellen. We have a question asking if doctor's appointments are deemed medically necessary. We would say yes. Students should be excused if they need to attend medical appointments. We think that would be something OCR would expect to see. Flip through some more and see if we can find some that are not quite as complicated and we can answer quickly. On the flip side, we have a question is whether medically necessary absences include absences to care for children if it is medically necessary for the child. we believe the answer under Title IX is no. The absences need to relate to the pregnant student's own medical needs. If after childbirth, the child needs medical appointments, those would be considered on the same basis as any other absences under your absence policy.
All right, thank you, Christine, and thanks all of you for joining our program today. We hope the information provided was helpful for you and your organization. If you haven't already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback assists us in providing quality future programs. As a reminder, this program is pending approval for continuing legal education credit. Please download the certificate of attendance from the certificate widget at the bottom of your screen. A recording of the webcast will be available tomorrow for watching and sharing. Once available, a link to the recording will be emailed to you. Christine and I will look through these additional questions and see if there are any that we are able to respond to in a timely fashion, but feel free to follow up with us if you have additional questions. Please be sure to join us for our next webinar on labor and employment year in review on December 10th, which is right around the corner. This concludes our webinar. Thank you.